Okay, well, welcome everybody to the Human Rights to Water and Sanitation Study Group here at the Harvard Kennedy School of Government. It's a real pleasure to introduce Ana Paula de Barcellos, who is a Takemi Fellow at the Harvard School of Public Health, which is a program in the Department of Global Health. And she has a really interesting background in that she has a doctorate in law and is a professor at the State University of Rio de Janeiro in Brazil, and has written actually quite widely on human rights and constitutional law. I was looking at some of the titles on your CV, but but they're all in Portuguese, so
yeah, that's true.
I won't attempt to pronounce those here, but has a real interest in social and economic rights, specifically healthcare, education, and she's going to be speaking to us today about the role of courts in improving access to sanitation. So please join me in welcoming Ana Paula.
Well, thank you very much. I'd like to thank God for the opportunity to be here. Thank Tramila for the invitation. Thank you for coming. So, in this afternoon, we are going to talk about this sanitation and courts relationship. Just before that, I'd like briefly to give you some background. First, why sanitation and courts together, these two ideas? Well, I don't really need to talk about how important sanitation is for public health, but perhaps I may need to talk that in Brazil this is a huge problem. More than 50% of Brazilian homes do not have access to any sort of sewage treatment. So sewage is usually discharged untreated in rivers, causing every sort of problems, as you may know. And well, the rest of the world is not doing very well too. As you probably know, the WHO Millennium Development Goal for Sanitation is not going to be accomplished by 2015. And what courts have to do with that, besides the fact that I am a law professor and a lawyer? Well, mainly two ideas here. The first one is that, well, social rights litigation is going on and increasing dramatically in developing countries and in Brazil as well. Just to give you an example, in the last 10 years, several thousands of lawsuits are filed every year in Brazil against the federal government, against state governments, and against local governments asking for healthcare services, usually drugs, usually private goods, usually drugs and some sort of procedure. To an extent that the state of São Paulo, for instance, organized a public facility just to deliver drugs for the winning plaintiffs. So it's not a real public facility, it's a facility just to deliver drugs for these group of people. So this is going on. We cannot deny it, and so how we can deal with that. And the second idea, why courts and sanitation? Well, we kind of know that sanitation policies offer little political incentives to governments to engage with them because of their low electoral returns. It's a long-term policy, expensive. The benefits associated with this kind of policy are not very clearly perceived by the population, so it's kind of comprehensible that governments are not quite willing to engage with this kind of policy, which may suggest that courts are or can be or may be a suitable place to discuss this kind of rights. The final background note I would like to share with you is about Brazil legal framework for sanitation. So in Brazil, sanitation, and I'm talking about sanitation broadly. Of course, sanitation has several aspects, and my research is focusing on sewage treatment. But sanitation, broadly speaking, is a public service in Brazil, and it should be provided by municipalities mostly, so local government. In some kind of situations, the states can participate too, but mostly by municipalities. There are constitutional and legal provisions commanding that this service must be universal, so all citizens should have access to this. And well, finally, water and sanitation services are not free of charge in Brazil. Subsidies apply, but they can be and usually are charged kind of a fee. Well, going to our main aspects, I try to organize my talk, and you feel free to interrupt and ask whatever you want. I try to organize in two great parts what I'd like to share with you. The first part, I like to present or to propose 4 models of relationship between courts, litigation, and policy making and policy implementation. And then in the context of these models, I'd like to present my research is an in-progress research, but how they connect with these models and what kind of preliminary result I already have to share with you. So moving to this first idea, this first model I'd like to share with you is a very ordinary model how courts and litigation connect with policy execution, policy implementation. So in this first model, usually we have the Constitution providing for some right. Then we have a law providing more detail for some kind of right. So these are models that can be used for social rights in general, not only sanitation. We have a policy designed. This policy is being executed well, but some problems occur. And the person that is being affected by this failure in the policy execution, well, he or she is going to court. So imagine that we have here in the United States a Social Security benefit designed by law. Someone qualifies, but for some reason the system does not recognize that, so the person goes to court. And well, he or she will ask usually for the proper execution of the policy and sometimes for damages. What kind of impact this can produce on policy making? None. We already have a policy. Nothing is going to really impact on the policy making, but these court decisions can help improve the policy execution. This is quite common. This is what happens in civil law systems. This is what happens in common law systems as United States. Nothing really new here. The second model describes a quite different situation. In this second model, someone, a group or an institutional player or someone that has standings to file this kind of lawsuit will challenge the law or the policy as unconstitutional or as illegal. So the whole law, the whole policy. And well, if the court agrees with the plaintiff, what is going to happen is that what the plaintiff requests is that the law or the policy is declared void. And so the consequence here is a quite different one. If the court decision declares the law or the policy void, what we will have then is no policy or no law anymore. So the court decision is able to kind of free the space, the political space, for a new discussion. This is to some extent what happened last year here in the United States about the Obamacare. Some aspects of the law were challenged as unconstitutional. The Supreme Court considers some as okay, constitutional, and some others are as unconstitutional. So here the impact also is kind of minor, but you can have a free space for a new discussion. The third and the fourth model are getting closer to what is really happening with social rights. In the third model, the elements are the following. We have a constitution, we have a law providing for the right, we have a policy already designed, but the policy is not being executed. This is unfortunately quite common in developing states, in developing countries. Sometimes law is passed and the policy is designed just for symbolic political reasons. So just to give you an example, the former Brazilian constitution the Constitution of 67, 69, provide that the federal government should guarantee that every worker had access to summer camps. Well, this never ever happened. And no one was even trying to get it enforced. In the city of Rio de Janeiro, where I come from, we have laws since the 80s providing for ramps in the beaches. So the city should build ramps on the beach so that wheelchairs users could have access to the sand and to the ocean. I can tell you that it was not before 2 or 3 years ago that these ramps started to be built. And I can tell you too that most Rio de Janeiro's beaches do not have this sort of ramps. So what's going on here, sometimes the law or the policy is passed for symbolic reasons. Sometimes the groups that were able to get the law passed or to get the policy design do not have enough political strength to get it enforced after that. And so what happens is that these groups go to courts. It's cheaper in Brazil, it's easier frequently, and usually you can get a faster answer from the courts than you could have from the political discussion. Sometimes also the interested groups are not politically articulated. So sanitation would be a very typical example. We are talking about groups of people living very far from their works, working long hours, spending a lot of time commuting, people that usually do not have access to technology to get easier in political organizations. So these people are not politically organized, articulated to put pressure on the public officials to get the policy enforced. And another element here that will take this discussion to courts is that in Brazil, as in other countries too, we have this kind of institutional players that can file this kind of lawsuit in the benefit of communities. So in Brazil, we have two great groups of this, what I'm calling institutional players. We have public attorneys and we have public defenders, and they can file this kind of lawsuit. So if they see a policy not being executed, then they can file a lawsuit in the benefit of that community that, for instance, do not have access to sewage treatment, although there is a policy designed that they should have. So they go to court. And
can I just ask a question?
Yes, of course.
Are those public agencies, or are you talking about?
Yes, no public agencies.
And do they need to have a client, or they're just basically saying the law is not being executed?
Public defenders usually need to have clients. Public attorneys don't need that. So they can just go to court and say the policy is not being executed in that community or in that community, even if no one in the community ever asked them to do that.
And the word public defender here doesn't just mean in criminal cases?
No. Okay. In Brazil, they work both in criminal and in civil cases, and in cases like that, for instance, in civil rights, social rights, wherever. So thank you for your clarification. So what these groups or these public and institutional players are going to ask from the court, from courts, well, they can ask private goods. I'm not really interested in this possibility, but this is always a possibility. So they can go there and ask drugs, for instance, and procedures. But my main concern is with this first kind of request, when the plaintiff, whoever it is, asks for the enforcement of the policy within a community. Well, court can say, no, separation of powers, I don't want to deal with that, go to the executive branch and put pressure on them. Or, or the court can say, yes, you are right, there's a law, there is a policy designed, and this policy is not being executed. We are here before a right, and this right should be granted. So if the court say yes, we can have an impact, a real impact on policy implementation. usually this is not going so smoothly, this is not so easy. If the defendant is willing to transform this court decision in a political priority, great. So again, in the ramp example, if the city of Rio de Janeiro is willing to do that, to build the ramps, great. Anyway, court and the city will need to establish some sort of dialogue to fix deadlines, because of course the city is not going to build all the ramps in a week or so. We have resource allocation problems, so we have to plan, and some sort of dialogue will have to take place, at least dealing with the deadline stuff. Well, if the defendant is not really willing to obey the court decision, so other enforcement issues may arise, and the court will have to monitor. Of course, the court has some powers. They can send the mayor to jail, but well, the court will not really use this so easily. So some tension will happen here, and that's why in literature we have this the importance of these external elements to get the real impact of a court decision on the policy implementation. We will need some movement out of the courts to help to enhance the chance of the court decision to get really enforced, and the policy implementation really receives this kind of impact. So we will need media, political mobilization, we will need sometimes international pressure can help a lot, and well, after that we can have this policy implementation. The fourth model is quite similar to the third one, just that it's even more complex, because in this fourth model we have a constitution dealing with some right. We have a law very vague and broad, not really designing anything, or we don't even have a law. So the constitution provides for right to life, for instance, right to health, housing rights, sanitation rights, these broadly. And well, no policy has been designed yet, and this is the key problem here. So again, the interested groups or those institutional players we were talking about, public defenders or public attorneys, they go to courts and they ask, again, private goods when possible, but they can ask, and they actually ask, that some policy must be presented and or implemented within a deadline that the court will fix. So in this fourth model, as we don't have a policy designed, the court will face emptiness, let's say. So the plaintiff usually will ask this kind of provision. So that's that the executive branch or the agency in charge has to present a policy in a deadline. Well, again, the same kind of problems may occur. If the executive branch or the agency is willing to do that for some reason, great. But if it is not, we will have all of those enforcement issues again, with the additional complexity that not only deadlines for the presentation of the policy will need to be discussed, but also the court may need to look at the policy that will be presented to check if it is valid or if is enough for constitutional and legal parameters. Well, these have been said, we can move to my research that I would like to share with you where I am and what I am doing here. And connecting to the models discussion, sanitation in Brazil and sewage treatment in Brazil will deal with Model 3 or Model 4. So depending on the city, we will have already a policy design but not as executed. But in other cities, we won't have any policy design yet, so we will be dealing with the fourth model and all the problems it encompasses. So, what are my research questions? And this research is in progress, as I told you. I have 4 main research questions. The first one is, well, are there, after all, lawsuits dealing with this kind of stuff? Are there lawsuits in Brazil or in other places asking courts to enforce sewage treatment, the access to sewage treatment systems? And this is important because social rights litigation and health care or health, more broadly speaking, litigation usually deals with private goods, with drugs and procedures, and not with public goods. So the first question is, well, are there lawsuits dealing with this kind of request? Then, well, what kind of answer courts are providing? How are courts behaving toward this kind of requests, if they exist, of course? Third question, how courts are dealing with enforcement issues, because if a court decision can be very great, but if it's not being enforced, little use of it. And the fourth question is, well, are courts' decisions really being enforced? So how effective are they? I have 2 main research outcomes that I expect from what I'm doing here. The first one is to know whether this is a real path, a feasible path to enhance access to sanitation rights and to sewage treatment. I'm so sorry about that.
I'm sorry. I don't know why you're doing that.
So what I'd like to know with litigation, if going to courts is a path, at least in Brazil, to get there or to help get there. And the second outcome I like to get or to come up with is to propose interventions that can enhance the chance of court decisions to really have an impact on policy making and on policy implementation about sanitation rights. Well, what kind of preliminary results I already have and I already can share with you? Some. The first one is that, about the first question, if there are lawsuits dealing with that kind of issue, well, in those countries, some in Latin America, some in Asia, some in Africa, it's interesting that clean water litigation is quite frequent, but sewage treatment lawsuits asking access to sewage treatment systems are rare. I really don't know why, but maybe because, well, enforcement issues for this kind of requests are tough, so maybe this kind of discourages interested groups in using litigation for that, or because clean water is a priority there, and so probably litigation is kind of focusing on that. In Brazil, differently, we have several collective lawsuits. Collective lawsuit, I'm using a lawsuit that is asking this kind of public good, so the system or the policy or something like that, not private goods. Some data we already have, it seems that most of lawsuits are being filed by the public attorney's office. Some I already have seen some filed by neighborhood associations, but most of the lawsuits with this kind of request are being filed by public attorney's office. But it seems that the public attorney's office does not have a policy for this kind of right. And why I'm saying that? Because what you can see, although the research is not finished, is that you don't have a regular pattern of lawsuits across the country in cities that does not have access to sewage treatment. What you have is a concentration of lawsuits in some places, usually filed by the same person in the benefit of different communities. So what the data is kind of showing is that probably these lawsuits are filed much more as a personal initiative of those people than as a result of an organized policy toward the issue.
And at some point, are you going to mention just what the laws that would be relevant?
No, but we can talk.
A minute to just say so.
Yes, of course. Do you want me to do this now or then?
Whenever.
So, okay, so we can talk a little bit about that. We have in Brazil the Constitution providing for sanitation rights, and there is a lot of discussion. If you want, we can discuss that, but about who is the level that should provide the service, but mostly it's the municipality, as I told you. But the federal government has enacted some laws about that. So we have this national legislation about sanitation, and each level, the federal government and the state governments and each city must design the policy. So the federal government should design a national policy. Usually the federal government should help funding states and municipalities. So each state has to produce its own sanitation policy, because although the cities are the providers of the service, you have a lot of connections, natural connections, of course, that you have to consider. You have funding problems because some municipalities will not have the money enough to do. So we have a lot of stuff going on, and so states have to design their policies in an integrated way with the cities, and each city has to have its own policy too. Some cities already have, some cities do not have. That's why I told you that in some places we are dealing with Model 3. We have a policy, but it's not being executed. In some places, Model 4. What we have also, besides that, is that this national law defines sanitation in 4 major activities. We have water, clean water. We have sewage treatment. We have solid trash, dealing with solid trash, and we have this, I don't really know how to describe it in English, but we have this organization of water, but about rivers to prevent floods and stuff like that.
Water resource management.
Water resource management. So this is considered here now in Brazil as sanitation, these 4 services. And well, sewage treatment and water and garbage, solid waste, these are from for the municipalities to provide, and the other one is a coordinated effort from the several levels. So what we have now in the legal framework is this effort of designing policies is going on, but for years now, several states have state-owned or state-controlled companies in charge of providing water and sanitation service. We have a lot of fight between states and cities because of, well, money and service quality, funding, etc. So in the administrative level, this is what's going on, but some places do not have even this kind of company or even this kind of service going on. So I don't really know if this is what you would like to know.
That's a great, very helpful explanation. One final point. When you say that it's in the Constitution, what specifically is in the Constitution, and does the right to sanitation,
yeah, the diction, this is very interesting because the diction is not a right diction. The diction is in the list of the obligations of states, municipalities, and federal government. And so but interestingly, and I'm going there in a minute, the courts consider it a right. So the diction is not really having all this impact. We have a list of rights, and sanitation is not there, and water is not there, but they are in the list of duties, but courts are dealing in the same way, and it's interesting. Yeah. So the public attorneys are the most common plaintiffs for this kind of lawsuits. an interesting information that I've been in contact with public defenders because I was kind of surprised that public defenders do not show as plaintiffs in this kind of lawsuits. And well, this is a kind of qualitative data, so some sort of interviews, not very systematic, but public defenders report that they do not receive complaints about the lack of the service, although they know the service is not being provided. And their interpretations that, well, people do not have much, the concept that they are entitled to this kind of right, so they just consider that's the way it is and nothing's going to change. And to some extent, this explains why public attorneys that do not need this complaint from anybody, they can just file the lawsuit, are showing as the most popular, most frequent plaintiffs. Another preliminary results that, well, most lawsuits are dealing with urban communities, not rural ones. And well, a final preliminary result that I think is important is that no one is really discussing costs and funding. So nor the plaintiff, nor the defendant. The defendant usually says, well, it's too expensive, I cannot afford it, but figures are not going in the discussion in the courts in the same way. So what kind of result? I kind of already told you, most of the time positive. So we have already some federal and state courts decisions stating that sewage treatment access is a right and it should be provided, so granting plaintiffs' requests. And the Brazilian Supreme Court has already upheld 2 of these decisions, in some way signalizing that it's going to agree with this kind of understanding. Well, how courts are dealing with enforcement issues? Usually courts are just establishing deadlines and deferring all the other decisions to the executive branch to decide over technical solutions, how to do, and whatever. Well, our court decisions are really being enforced. I still don't have this answer. It's too early. These decisions are quite recent, but we already know that some enforcement issues are going on. So monitoring is not really going on. Courts do not have this equipment, this structure to keep monitoring, and so we already know this is going on and probably will get worse. The preliminary conclusion I can share with you is that, well, I think yes, Brazilian courts are willing to play a role in fostering access to sewage treatment, so it's a possible path. And what kind of envision interventions I'm thinking of? Well, of course, all the interventions are in my field, what I can do, what I can think of. Well, I think one intervention is try to help the public attorney's office to develop a structured policy towards sanitation rights and sanitation litigation, to get to the places that they are not getting this moment. As the second and the third intervention, they are connected, they are legal, but they really want to enhance those external elements I was talking about that can enhance the chances of court decision to get really implemented. So what I'm envisioning now is to try to get the Brazilian Green Party involved in this kind of discussion. It hasn't been so far. And to try to get the Brazilian Green Party to file a lawsuit directly in the Supreme Court in Brazil, asking the Supreme Court to declare that sanitation right is a right, after all, and that sanitation policies are mandatory. This kind of decision will have, well, little legal effect, but they can help trigger this political debate around the sanitation discussion that can enhance the chances of court decisions that are being delivered to get implemented after all. So that was it. Thank you very much.
I think that's really interesting, actually, and I think we're going to open it up to some questions, but let me just start off with a couple.
Okay.
So one is, actually, let me start off with my last question, which is from a research strategy standpoint. It seems to me like that you're very focused on the courts, which is very interesting, especially because in many other parts of the world, the people look to the courts, but there's this sort of enforcement challenge, and that it's really where the rubber hits the road is really in the municipal authorities, in the utilities. Have you thought about actually interviewing as part of your research at the municipal level, the actual authorities that are responsible for budgeting, for actually doing the infrastructure?
Yes, but in a second moment, I think that would be two different things. After this kind of picture or portrait of what is going on, the cost, and really assessing how much this will cost for each city. We don't really know, but I think it's possible to know or to estimate at least, to get more reality to these lawsuits, both to plaintiffs, to courts, and to defendants, because this can be a huge issue in the enforcement moment. And this aspect of interviewing the companies and the administrative branch can be a great idea. I think I thought about that, but I'm not doing that. But it can be an agenda. It's an interesting idea.
Got a few more questions, but let me see if other folks have some. Yeah, please.
Yeah. As I said, I'm an architect, and I've practiced my whole practice in New York City. I'm originally not from there, but I've practiced there. I've also practiced in rural Connecticut, which has some really interesting sanitation standards for septic. So I've sort of seen urban and
Rural.
tightly controlled rural conditions. So in New York, back in the mid to late 1800s, there were severe overcrowding situations, particularly in the Lower East Side. There was a lot of tuberculosis, and it came to a point that was unacceptable. And really, it came down to sheer overcrowding, putting too many people into too small a space. And so the solution to that was not taking lawsuits to the city to say we need better sanitation. It really came down to how many square feet can a human being occupy safely and in a sanitary way. And I can tell you, having worked in New York City, it is, it comes down to the square foot, and it is enforced to the maximum today. And so the question is, by coincidence, you get this $9 million in Rio.
Which one?
I look at, this is on page 52. I mean, I look at that picture and I say there is no technical or physical solution to provide a sanitation solution to that kind of density, that kind of ad hoc construction. I mean, you've got ad hoc construction, you've got ad hoc or non-existent sanitation systems, and you're suing somebody to say one of the solution, that the solution is this does not work, and you have to me it would be, what did New York do over 100 years? It said, to be realistic, you can only support this many people per square foot, and we know what our sewage systems can process out on the peripheral of our city. That's the physical solution. We work backwards, and therefore you can only have this many people in this amount of space. That's the realistic final solution. And I don't understand where you're coming from.
Yeah, I think you're completely right.
In other words, I hate to tell you the news, but this is not sustainable.
No, I think we kind of know that.
It physically has to be, dropped down in density.
Yeah.
And you can't provide ad hoc, patches to this condition.
Yeah. And what you were telling us is that before any sanitation policy can go on, you have to change that.
But I mean, it's a failure of your cities and your government to look at this and say, well, I'm not going to do anything. I'm going to wait till these citizens come sue me. And that's just.
But I might just say, Brazil though has pioneered. condominial sewage.
Yeah, but not for this environment.
But
in Brasilia and
the example of Sao Paulo, we had a presentation on that a couple years ago, and my understanding, if I recall, is that there was a very strong, innovative city leader who basically took the mandate of universal access to heart, and actually really thought about design and engineering and how is it that you can basically they actually redesigned the piping that would actually have to go in favelas. So they were actually putting them in, I don't know if Sao Paulo, the way that those favelas are.
They are different there because they are horizontal slums, and in Rio they are this kind of rock slums. So this is a geographic problem. But you were right. This is if you were going to design any policy to this place, to these people, it's if a sanitation policy is already complex in itself. Here we have housing problems and transportation problems because we are going to remove these people where to. And these people, why are these people here? Because the place they work is nearby, and the place they could go to is very far, and public transportation does not work well. So we have a lot of other problems, and you were right. You were right.
I mean, you could argue that there because there wasn't proper structure to draw the line and say there's a limit, to what would allow them in this.
Yeah, but this is all illegal occupation.
Well, that's what I'm saying.
Yeah. So the city was not able and is not able to enforce its laws.
But if it's not able to keep people from inhabiting this way, it certainly has no capability to plumb this.
Yeah, that's true. I don't.
First things first.
I don't know, but I certainly will look at if there is any lawsuit dealing with slums. Usually they deal with poor urban areas, but not slums. So far, yeah, but suburbs, not slums. But I'm not sure. But I keep an eye on it because I am figuring out how a public attorney will come up with a real idea of solving this kind of problem. But I don't know. All the lawsuits I've seen so far are not dealing with this kind of environment.
And is that because of the underlying land tenure questions?
I don't know. I don't think so because these other areas, poor areas, they also have landowner problems. They are also illegal, but they are not really slums in this on rock slums. They are more horizontal. They are in the suburbs of the city. These, I don't know which is one. I think it's Rocinha, but I'm not sure. But anyway, I will keep an eye on it and how it will develop. Yeah.
I felt a little bit lost in this. What does it mean to have the right to sewage treatment? And so are we talking about the right to some kind of sewage effluent that leaves my house that I can put it into some kind of public pipe and it goes away? You use the term sewage treatment, which is a really different question than am I entitled to something like these condominial pipes do. They don't treat the sewage. Mm-hmm. All they do is carry it away. Mm-hmm. So from a private citizen's perspective, right? From a private citizen's perspective, I'm concerned about my right to be able to have the effluent flow away. I find it hard to believe that the Constitution gives me the right to treatment of that sewage. And then is that primary treatment, secondary treatment, tertiary treatment? And why would that be my right? I mean, it's very much a public good issue. So I don't understand what's the constitutional right. What are you talking about when you say sewage treatment, not the right to sewage, to an effluent that will leave my house, a route to leave my house? That's not very clear. And then the question of the standing of, well, then who would have, because I don't suffer. If I flush my toilet in Brookline, I have no idea where that goes, and nor do I suffer whether it's primary or tertiary treatment. That has no bearing on me. So it's very hard to imagine that I'm standing in a court to say, I have the right to tertiary treatment. And that isn't actually how, at least in the United States, our laws have worked. With the Clean Water Act, it's really been about we all have the right to a swimmable river. And it happens that my sewage is destroying the river, right? But it's a right to the clean water. And I think in the U.S. there have been two things. There have been environmental groups that have sued, not private citizens for the right to sewage treatment, but environmental groups have sued to demand that the rivers be swimmable, that wildlife be protected. There's been environmental groups, and there's also been, not from a legal perspective, but from a cost-benefit analysis of if you have a lot of untreated sewage going into your water supply, you're going to pay for that on the other end in your public health systems, which certainly Brazil has an interest in trying to reduce the amount of bacteria, viruses, etc. So that's not a right, though. That's an issue of. And that last question is, a public defender being the one that would, isn't the public defender appointed by the government? So, no.
No, not in
So,
Brazil.
who is a public defender? What's their mandate? Who pays them?
Okay.
And why would they sue the government? You would not expect a government official to sue the government. So.
Okay, so a lot of questions here. So let's try to deal with that. Thank you for that. Well, sewage treatment, what I mean for that is the treatment, not really getting rid of your sewage, so the treatment. What Constitution? The Constitution provides broadly for sanitation. The law describes those four aspects, and inside the sewage, both the delivery of the sewage and the treatment. So it's legal in Brazil that the sewage must be treated. Of course, the law does not make the technical options, even because the technical options will vary a lot, but so it's illegal, and this is what I'm talking about. I'm not really talking about just the access to the pipe to get rid of the sewage, but to get it treated. And well, do I have a right to get my sewage treated? And this is an interesting discussion in Brazil, because you have this individual rights and collective rights. And we have in Brazil and in Rio several lawsuits from private parties, because what is going on in their neighborhood, they have pipes, but well, the sewage is being discharged in the river just nearby the community. So the private person is going to court and asking, well, I have the right to have the sewage treated because it's being discharged just here, a lot of health issues to my community. And courts are saying, no, you can't ask for that because this is a public good. But when you don't have an individual right to that, as you were saying. But when the public attorney or the neighborhood association or the public defender will go to court and ask for the collective, in the benefit of the collective, the Brazilian legislation accepts this kind of collective public good. So this is a right. You cannot tell it's not a private. You cannot share. You cannot divide. But it is a collective, and this is okay. You can go to court to ask that. So this, as Shamila was talking in the beginning or at some point, the Constitution does not provide for a right. It provides for a duty to the government, but courts have recognized the right directly from the duty and connecting to health and to environment too. So this is how it works. About the public defenders, as the public attorneys, they are paid by the states or by the federal government. We have both there, but they are not really appointed. They are independent. They are nominated after a public contest, and they are not for life, but till 70, I think. So they are quite independent, and they can, and they really do file lawsuits against the state, against the branch that pays them, and that's okay in Brazil. They don't have any duty not to do that. The government has its own lawyers, and this is a different agency of state lawyers for the federal government, for the state government. government and for the municipality, but this is a different agency. So the public defenders, they are supposed to file lawsuits in the benefit of poor people, or file or defend poor people in criminal, civil, or whatever, what kind of lawsuit. Collective, as this kind of we are talking about, or individual ones. So I'm not sure I covered.
I know you mentioned public-private partnerships
Okay.
As being used by some municipalities already to address sanitation issues. I was wondering if you had considered the potential for public-private partnerships in the future to work with more municipalities or other initiatives that develop in the private sector.
Well, I think when I come to the cost discussion, I think this could be an idea because I really don't know how affordable will be this service if the users will be, how much they can pay for that. Mm-hmm. So which will be the size of the deficit. Right. So how much money the government will have to put in it, and so how much money the private sector could get from it. So what kind of solutions you can come up with. Public-private partnership I know they are being discussed in the context of sanitation in Brazil. I don't really know how deep is the discussion because the policies are not even designed yet, but I know this is an area in which public-private partnerships are being considered there for these infrastructure buildings and so on. But I don't really have much information about that. Sorry. Mariana may have. Yes.
So I think I have one question and then a few comments that relate to a lot of the points that were raised. But the main question goes back to the public attorney's office, right? Okay. Which is, it's an interesting arrangement because it was something that Brazil created that's not, it doesn't exist in other countries, and it's not a fourth branch of government. Like they just, and they're known to sue in the public interest. Right, so that's their main mandate. They are supposed to go to court, they don't need a client, and they are meant to protect the public interest. So there was another discussion at the David Rockefeller Center, I think a few months ago, about how Brazil has advanced so much in environmental policy because we have these agents, right, who are going to court and enforcing the government to protect the environment. So it was interesting to me when you're comparing Brazil with the other countries that you looked at, that you came up exactly with the result that Brazil has had much more lawsuits for this than these other countries. And I'm wondering to what extent we can ascribe that to the fact that we have this unique institutional arrangement of having a public prosecutor's office that is bringing this lawsuit in the name of the public interest. Right, so I think that would, I know it's a hard question to answer, right? It's counterfactual, but I would be interested in your speculation about it.
Yeah, I think maybe you were right because, you know, even in countries where they accept this public interest litigation, so they accept that a person or a group will go to court in the benefit of a third group. Even in this kind of arrangement, what you have is that, well, this needs to be your first job, to go to court and to fight and to monitor and to go to try to get public attention and stuff like that. And well, in sanitation, it will be hard to get the interested people to do that, as we were talking about. So who will do that? Government's not really interested in that. It will not produce any electoral result. Well, the real fact, people are quite too busy trying to live. So who is going to bring this kind of lawsuit? So I think the public attorneys are a very important player in this context. And when I have the final results, we can have how much of these lawsuits really are being filed by the public attorneys, and public attorneys have the capacity of monitoring to, if they are willing to do, they have this. So I think maybe you were right. I don't have the information about these other countries, how they organize, who is really filing those lawsuits, or who could file those lawsuits. So it's hard to compare, but maybe you have a point here.
So I think the other two issues are just more comments. So regarding the public-private partnership, we have a new law in Brazil. And last time I was there in December, I talked to a whole group of people who are implementing the public-private partnerships at the federal level. And basically what they said was that there is a lack of capacity of technical personnel to actually design, because these are really complex financial instruments. There is like, 2,000 pages contracts that go, and they said that the federal government created this Empresa Brasileira de Projetos, the Brazilian, it's a
project company,
yeah,
whatever.
It's a company at the federal level that's in charge of designing these projects. And then I move on to talk to some people at the municipal level, where they said we don't have personnel, like we don't have capacity. Like even if someone showed up and said, here's the money, we lack the Empresa Brasileira de Projetos doing it for us. So I think one interesting thing that maybe you could consider in your on the possible outcomes is for a court to mandate for the government to get the Empresa Brasileira de Projetos to work for a municipality, designing some sort of concrete plan on how to structure the financing and the entire arrangement. Right?
No, that's good.
And I think the other point, and this is goes back to the paper that I shared with you a few days ago, the complexity of doing the sanitation came up again in the doctor class. There was a one-day full discussion about Brazil, and someone an expert, I think she's an architect, an urbanist, and she basically showed the favela.
One of those troublemakers.
Yeah, and she showed the favela and said, look, like you need to start over, right?
Yeah,
because
but
to get
that's it.
sanitation here, you need to redesign the urban plan, like it's a whole replanning, right? The rezoning, urbanization, everything goes together. So you cannot just go in and say, I'm going to provide water. And I do take that point. I think Ana just did as well. But in the right to health, what we have seen is that people are going to courts, and that's creating political awareness of the problem, which is indirectly, I think, prompting governments to start doing something or thinking about stuff, right? So I think maybe the response here is not going to be litigant, court mandates, the pipe is there, right? It's going to be a more indirect loop.
I've said too much, but I guess my original point was in the 1800s in New York, it never happened from the bottom up. The city fathers looked at this horrible condition and said, this is intolerable. And they said, we have to set physical limits. And so instead of the people here trying to sue, couldn't they maybe politically organize and say, we need a government from above that recognizes this problem and start? But although the answer may be, well, you lost your house because we can't support this kind of density. So I mean, but are you willing to entertain hypothetically that the solution delivered back to you could be, you just cannot support this kind of density, period. That's just a physical reality. Can't do this.
But what Mariana is telling, I think, is
what if that
can give you some hope.
What do you do with that
That
message?
density is much lower than Manhattan. This is much lower. There's no high rise in there if you have it.
Well, we have a lot of slums. This is just one. But I think you were right. Well, at the end of the day, the solution will have to come from the top. So what courts can do is, or at least I think what courts can do is to play a role of agenda setting. And so if court decisions are ordering the city, well, you must provide, you have to do something. Well, the city will say, well, I can't do what you were telling me to do. At this moment, I need to rearrange this, I need to remove these people. But at least some political discussion about doing something will take place. Well, I don't really think the court decision will solve the problem, but it will be part of the fostering the discussion to deal with the problem at least.
Okay. When it comes to the implementation of the actions of the policies, I'm interested in knowing the level of commitment of the ministries of health or the environment that should be involved in Brazil at the moment.
Yeah. At this moment, sanitation is not directly connected to the Ministry of Health. It is connected to the Ministry of Cities. So although there is an obvious and huge connection, from the administrative point of view, sanitation is not inside the Ministry of Health discussion, but in this other, no, not even in the environment. It is in the Ministry of Cities. That's the name we have there. Cities. Yeah. So just planning in cities, and so sanitation is in this. This is a ministry that, well, has some connections with Ministry of Health and other ministries, but sanitation is behind this branch.
So the political order goes directly into the Ministry of Cities and has nothing to do with the other ministries.
No, it is a ministry too, a different one. So we have a lot of ministries in Brazil. We have the labor ministry, we have the health ministry, and we have this cities ministry. And this is a federal agency, let's say, or a ministry inside the federal government. And you usually have in the cities and in states secretaries for water and sanitation. So they are usually different from the Secretary for Health.
So I think this has been really very interesting. I mean, this is a really great discussion because I think some of the points you were just making, for me, in some ways, when I'm thinking back on your presentation and actually wanting, and I guess your data is not yet there, but wanting some of that granularity in terms of what the cases, what are they really involving, who are they really involving, and in particular, you brought up a really good point, which is what do we mean by sanitation? So if you think of it from a human rights standpoint, right, the international human rights law, which be interested in sort of a comparison, a comparative analysis, but that's really about the right to have a dignified place to defecate, right, and to not be exposed to your excreta. And so there's a question about, well, does that really mean, does that include the piping? Well, there's a whole host of actors that are trying to innovate, Gates, reinvent the toilet, thinking about decentralized solutions, sort of modern compost toilets, so you actually can be in these really dense environments. And then the treatment question is yet, as you point out, yet another step in the equation. And I feel like the fact that, we're using the word sanitation sort of almost interchangeably, but each of these, really the rights holder and the duty bearers, or the attached duties change. And in the other parts of the world that you were looking at, I'm curious whether or not it was, if you're really comparing apples to apples.
Yeah, I know the data available for other countries are very broad, very generic. So you have clean water and you have sanitation. But most of the lawsuits abroad that I was able to find were about toilets. So were about toilets, were not, and that's why I report to you that sewage treatment is not really being discussed abroad. It's being discussed in Brazil, but it's not being discussed abroad as far as I can tell you. So there are lawsuits in India and South Africa and some other places asking for this basic idea of a dignified place to defecate and not to get connected to your excreta. So we're talking about toilets, not even about pipes, not even about getting rid of your sewage, and not even about sewage treatment.
So how come Massachusetts is not in your list?
Well, does Massachusetts have a problem?
If you're really looking at sewage treatment, right, and that you are right now in the city, that as of 20 years ago, there was raw sewage flowing into the Boston Harbor, and it took a series of lawsuits, the involvement of state, and you have also a federal structure. You have a city of Quincy, you had the federal EPA getting involved, but I think it might be a really interesting.
That's interesting. I didn't know that.
Comparison.
I'm interested in developing countries.
No, but you know, this is as I said, it's there's been it's a great case study. I think,
That's interesting.
for you.
I
Thanks.
would do a comparison. Can I make a couple of suggestions based on this?
Of course. Can I just
You know-
pick up something to write down? Sorry, Fatma. I just. But I'll be back soon. Yes, I do. No, thanks. Lisa just brought me. Thank you. So, please.
And actually, I mean, a few of us are old enough here to have been part of that fight for that right. So, pre-1970, Clean Water Act is in 1970 and 1972. Before that, there's no sense that there's either a private right, collective right, public duty to ensure clean water, which all the sewage treatment stuff really follows in terms of litigation after that. Before that, it's more the towns decide they want to do it just for their own sake. There's no obligation from the federal government. Here's a couple of suggestions. This public defender role is really different than the United States. I mean, that's fascinating. And I think if you're going to give a presentation in the U.S., you probably will make a stronger presentation if you explain that fourth role. And so as I've been listening to you, I'm wondering, where are the NGOs? We didn't have all the sewage treatment in 1960, and we really relied very heavily on our environmental nonprofits to do these cases. And they had trouble at first getting standing. It's like, this is not the Sierra Club's business, right? Where do you have standing? It took a lot of fighting. So there's this whole history of who has the standing to make that claim, right? We got the law, kind of the equivalent of your Constitution, pretty big law, but then who had the power, the standing to enforce that? And it is interesting that the public defender serves a position that we kind of relegate to our nonprofits, right? But now that said, Brazil is a very active environmental movement. So what's the role of the environmental movement, the nonprofit environmental movement? Are they part of these lawsuits? That's where we want this granular stuff. Of who's doing the, who
So
are they
far,
suing? Who are they?
not so far. They are not showing up.
They're not showing up.
Not.
Well, that's interesting. That's really interesting. And then another thing that came up was the money for it. That came out in a couple of places, right? So in the United States, and this is something I don't know or I don't remember the details of, but the federal government provided money to states and cities to create sewage treatment. And it was big, big bucks. You know who Michael Dukakis is?
Well, I don't know.
He ran for president, and he was criticized for having totally messed up by not getting the federal money for the sewage treatment, that we had to pay these incredible bills. Our water bills went up by like 5 or 6 fold, and the blame was Dukakis failed to get the federal money.
Okay.
But the interesting question was, to me, related to this, is what was it that forced the federal government to provide, and this was really expensive, to provide all of that money to cities and towns? We had the Clean Water Act, but it wasn't clear that said, and you must spend billions and billions of dollars on it. So I think that history is interesting. What's the obligation of the federal?
But do you know why? Or,
no, but
no. Okay, I can find out.
Very,
Okay.
very widely. This is a really, there's tons of literature on this. And then the last thing is this idea of collective rights, which I think is more a semantics issue than, because we have a collective right to clean water, a collective right to clean air. I think I think for the non-legal audience, we might need some help on that as opposed to private rights.
Okay.
The discussion you gave, I thought really helped a lot. But it seems like that it should be built into the presentation.
Okay. Thanks.
Yeah, I mean, I would just say that on the notion of collective rights, I mean, I think this is frankly the real like emerging discourse in human rights, right, in terms of thinking about the rights. So the third generation rights to an environment. You have folks that come out when you look at natural resources like water that, you know, the Elinor Ostrom sort of common pool resource type thing, trying to translate that and match that up. And there's tensions, right, because human rights is fundamentally very much about individual rights, and it sometimes conflicts with these collective rights. And I was just at a discussion last semester where there was a very heated actually exchange between a group of academics on this question of water and sanitation being individual versus collective rights, because depending on how you're thinking and looking, and in some ways, you know, we in the U.S. come out of a sort of regulatory statutory framework, and so we don't really think about it that way because we think about, well, we have the Clean Water Act, which is in some ways that environmental law is kind of substituting for this kind of collective right.
Yeah. In fact, in Brazil, we have three different class of rights. We have the individual rights, we have the collective rights, and we have what our legislation calls diffuse rights. Yeah, so it can always be more complex, and so but I think we can use collective to both mean collective and diffuse.
What is diffuse?
The diffuse would be, for instance, the right to information. So it's really something you can't divide. And the collective would be, well, to provide some kind of sewage treatment for a community would be a collective right, because you can sort of identify the community that's going to benefit from that, and in the case of information, you can't identify well everybody. If you broadcast some misleading propaganda, for instance, this violates a diffuse right. So, but thanks, because this is I didn't really know that this is a so particular expression, and we use it so much. But thanks.
I think just to add to that suggestion, and like distinction between ação civil pública and ação coletiva, I think like.
Do you think that?
I think so, because
Okay.
It goes together with the idea of the Ministério Público, this fourth branch, because we have two kind of collective action: the collective action of a particular group, or in benefit for a particular group, and we have the collective action in the public interest, which doesn't need. So, whereas in the U.S., where if you have a collective action, you need a concrete physical group that need to provide the names. In Brazil, we have the second type that goes, it's tied up with the Ministério Público, the public attorney.
The public attorney's office, yeah.
And so I think that's another important distinction.
Okay.
That is interesting for to understand.
Yeah, and it might be interesting in terms of your comparative analysis, because India, for example, has public interest litigation that can be brought. And I think even just like, you know, I'm curious, how are the courts perceived in Brazil? You know, it's
By whom?
just in general. You know, I mean, the thought that it, in many ways, so the reason I ask this is this. So as somebody who is trained in law, and you're sort of when you're in a legal, you know, at a law school, focusing on the courts makes sense, right? When you think about these issues in, say, a school of public policy, everybody goes, well, so what? Those are just paper rights. It doesn't really translate. So I'm curious, like, do this idea that the courts, you know, and I said you can look at many examples around the world where courts like India, very good at great pronouncements, but that doesn't really translate into action. So are there examples? It seemed to be that in Brazil, it is a very functioning judiciary that actually seems to have a real impact.
Yes, and well, I think we have an institutional and cultural and political environment now in Brazil that kinds of puts in the judiciary branch a lot of hope. So people are going to courts instead of voting, for instance, instead of engaging in any political activity. This raises a lot of other problems, but so the courts are really a place where people go to ask for drugs, to ask for consumer rights, to ask for a lot of stuff. And it has a huge impact. Of course, when we move to complex requests like that, you were asking a public good, you were asking something so complex that will take years to get there. Of course, the enforcement issues will rise, as we told, but if you have simple requests, if you need a drug, courts are more than willing to give you. If you need surgery, courts are more than willing to give you, and this is a problem. And this
is there a massive backlog of cases?
Yes, yes, yes.
I guess that you can also draw a lot an analogy to South Africa in that sense. That the courts have really been used mainly to enforce socio-economic rights.
Yes, yeah.
And so that when people say, oh, we're going to the local municipalities, etc., doesn't actually, because of the politics, necessarily translate anything, that they need to go up higher levels. And once you get that constitutional court saying, well, actually, yes, this is an enforceable right, you start seeing actually many things.
But what's interesting though is South Africa codifies this concept of progressive realization, right?
Yeah.
And as a result, the court actually gives quite a bit of deference to the municipalities in terms of how it's going to implement, but it doesn't sound like Brazil.
No,
it's like it's black or white. You're implementing or you're not, right?
Yeah, and courts, this dialogue thing between courts and the executive branch and the agencies are going on now because courts are moving to these kind of more complex lawsuits. And well, you can really say it's black and white and this kind of stuff. You can just say, go and build a sewage treatment system. That's not the way it works. So courts are being pushed to have the dialogue, and this is going on really now. Just to give you an example of the impact of litigation in Brazil, I think it was 2007. We have a city just nearby Rio. It's a city called Niterói. And in 2007 or 8, I don't remember, 80% of the health budget for the municipality was used to provide drugs that courts had ordered to be provided. And this 80% was dealing with 10 lawsuits. So it was very expensive drugs that were consuming the public budget for health. So we have a lot of problem there in this health area. That's a reason, underneath reason why I'm trying to discuss how courts can be used to discuss public goods, not just private goods. Because this is going on and we are having a lot of trouble using so much courts to do that.
One final question, if I might, then, is why the Green Party? You ended your talk with
yes.
all of a sudden bringing in the Green Party.
Yeah, why? Well, two reasons for that. The first one is that I think, the first is that I think I can have access to them, so this is a good reason. But the second is that, well, they could connect with this kind of idea, sanitation, because it is so connected with environment. And so they have an identity with this kind of cause. I could try to get any other political party, but I don't really think they would have they would so clearly show the idea that, well, this is an important thing, even if it is not producing electoral returns. This is important for health, this is important for environment, this is important for present and future generations. So this was kind of a choice.
You wanted them as a plaintiff? Or?
Yeah, because this was a legal problem too, because to file a lawsuit in the Supreme Court, you have standing problems. So political parties have this kind of standing, and so I would need a political party. I can try to get other people too, but political parties are possible plaintiffs for this kind of lawsuit, and it would be great if I get them. But let's see.
Great. Well, on that note, please join me in thanking Ana Paula.
Thank you. Thank you. Thank you.